I'm going to read this from a court case, Myers versus Nebraska. It says here, the established doctrine is that liberty may not be interfered with under the guise of protecting public interest. That's a Supreme Court case. So just because they think that they have to do something for the public interest, that they can't get away with it just because of that. Okay, they cannot violate any provision of the Constitution just to make the public feel safer. And just one more case here. Hale versus Henkel, another U.S. Supreme Court case, talking about rights existed by the law of the land long antecedent to the organization of the state and can only be taken from someone by due process of law and in accordance with the Constitution. Then it goes on to say, he owes nothing to the public so long as he does not trespass upon their rights. That should help settle that question. We don't owe anything to the public so long as we don't harm them or trespass upon their rights. It's that simple. No matter what excuse they come up with, their excuses are just simply not valid.
Hello, everyone. Welcome to this special presentation on the Constitution by the Commoner Law Group. You were just listening to Fritz van Mastright, the author and instructor of the Great American Law Series, our foundational course in common law that you can sign up for and start taking today. It's self-directed and online, available for you at commonerlaw.com, and I recommend it highly. We're going to go through some of the basics today of the Constitution because that's really the foundation upon which our country was created and the foundation upon which your court case is going to be won. So as long as we are still free people and the Constitution is still the law of the land, then all it is necessary is for people like you and me to stand up for that and actually use it in the court to establish our natural rights and to remind the government that its job is to protect our rights and not to enforce statutory laws. So thanks for being here. This will be the first in a whole number of trainings that we're going to be doing, as everyone who's fighting vaccine mandates ultimately is going to end up in court. When we started this process, when we started this project, we didn't know what would happen, because in the best case, we were thinking that the documents themselves operated with your aggressors, that is to put them on notice of violation of your rights, to tell them to stop. As you know, the substance of those documents probably by now. In the past, in other situations, those documents have worked to stop aggressors in their tracks. But this is a different time we're living in, and the scope and scale of the vaccine mandate program, international, global programs everywhere to force people to take vaccine mandates. It just continues and continues. Indeed, this morning, the headline on the local paper in San Francisco, the San Francisco Chronicle, said, "More get vaccines amid job loss threat." More get vaccines amid job loss threat. And the subtitle is, "Workplace requirement could be best motivator." So here we have the mainstream media right on their front page. They're basically celebrating people using threats to have you violate your own personal God-given rights. So that's the time and place we live in. It's unprecedented in my lifetime. And so I'm so grateful to be here with you, because I know that you are not like the average person. And whether you've understood something about the law through our trainings, or just some of your own research, or maybe you're just desperate because no one else is coming to save you, so to speak. The unions are of no help. Politicians are no help. Lawyers aren't coming through. And celebrities and all the people you might have thought were going to come through and stand up for you, no one is doing it. So in the end, you'll have to stand up for yourself, which is actually a very good thing. In common law, we all need to stand up for ourselves and for those in our lives whenever our rights are being violated. We can't expect other people to do that. So we're living in a time where there's enormous collusion between media and politicians, government, academics, and corporations to make us think that we have to take this vaccine when we don't. So we're going to stand on our God-given natural rights, just like many people have done over the centuries. And even though it's a big battle here, we have to win. People ask me all the time, Clint, does this common stuff work? Does it really work? And I tell them, not only does it work, but it must work. Because if we're to have a free nation, if we're to have any sense, any semblance of a free world in the future, it's going to come down to you and me at this time in history. So again, I'm very grateful to be here with you. And we're going to have an introduction to the Constitution today. We're going to make it absolutely 100% clear to everyone the difference between a common law approach in the courts and a statutory rules approach. So the word law obviously is ambiguous. It's just a word that people throw around. By using the word law, like you have to follow the laws, is really a misunderstanding. And we're going to go deep into that today and make sure that everyone's 100% clear. And then we're going to understand what this ex parte hearing is all about. What is an ex parte hearing? Why are we at the Commoner Law Group suggesting that you use the ex parte route to win? And in fact, you've been doing it all along just by submitting these documents to your aggressor. And in their default, they have already been adjudicated guilty. And now it's just a matter of getting a judge to order them to cease and desist and pay damages. So that's the strategy overall, but you need to understand what it really means because you're the one that's going to be standing up in court. You need to make sure you're standing on firm ground. Sue Ann Caesar is here with us today. She's our common law specialist who has won many court cases over the years and through trial and error. She'll tell you maybe some stories about her successes, and she's won both following the statutory rules and she's won with common law. So she knows the difference, and you need to know the difference because it's going to come up again and again. The court system currently is like the rest of our government is, and most people's opinion of our government is that we have to go follow the statutory rules. But that's not how we're going to be able to win this case. So it's important that everybody understands. And we're going to go through the fundamentals today to make sure that's the case. So hi, Sue Ann. How are you? Thanks for being here.
Okay, thank you very much. So yes, I'm very grateful to be here. One of the things I've told many of the other people that I've talked to on Zoom that I was in an accident in 2000, and when I got out of the hospital, I could barely walk, I couldn't talk, I couldn't read, and I couldn't write. And obviously I'm a little bit better. I don't know how much better, but definitely better. And so, but I started my law research in 1994 when one of my clients, because I was a computer specialist for 29 and a half years prior to that, asked me to go to a meeting that he couldn't attend. So I went, and I was blown away with what they provided. And what they talked about was taxes. And they said, you do not owe taxes. And so many people believe they owe taxes. And of course, I went through the process, and in doing that, eventually IRS no longer bothered me. When I got into that, I realized that federal laws do not apply to the average individual. It was very fascinating what had happened. And so I got involved with a law researcher, and he's really helped me learn about both statutory law and common law. And so I've been very, very grateful for all the things that have come my way. Well, one of the things I love to tell everybody is that I do not have a driver's license. Why do I not have a driver's license? Well, my law researcher gave me cases that showed me that the only time you are required to have a driver's license is if you are transporting persons or property for hire. if you are not paid to move people or things from one location to another, then you are not required to have a driver's license. Now, you only are required to have registration on your car if you have to have a license. And I had a student just before my accident. I was working with him and I did some paperwork for a case that he was in, and he apparently won that. But I had an accident before I actually knew that. And afterwards, he went out and figured out how to drive without a driver's license and without registration on his car. And he always had a brand new car. And he did this for 8 years. Then he did something not very smart, and they told him that if he did not go and get his car registered and a license, that they would put his wife in jail. And of course, he knew he had to do that, so he went and got license and registration, and then they picked him up and put him in jail for 2 years. So sometimes it can be dangerous if you do not understand what you are doing. So in the meantime, I had a total of 6 cases from 1995 until 2009, and I was 100% successful in all my cases. It was very fascinating because one of them, I actually had no license and no plates on my car. They stopped me because I knew the vehicle code very well. They wanted to take the automobile, but they couldn't. And they wanted to arrest me, but they couldn't because I wasn't in the car. They didn't see me driving the car. And of course, when you're a car, the car is not a vehicle. It is a car or a conveyance. And you are not driving. Driving is something that is commercial. You are traveling. So these are things you have to know. Anyway, went to court. He took me to trial. I had 2 officers there. And when it was all said and done, he did a big sigh and he goes, I find you not guilty. Now, I have no license and I have no registration on my car. How did he manage to do that? Well, one of the things I've learned lately is that if you do not volunteer, they cannot get you. But you have to understand how you volunteer, and that's a major challenge. So I put together a PowerPoint to discuss these things so that people know and understand that there is a definite difference between common law and statutory law. This is called common law versus statutory law. Well, actually, statutory is only rules, and they apply to those who are engaged in an activity to which the legislature can rule, meaning they can prohibit and regulate. But if you go in and you volunteer, it is not for them to know that you are volunteering inappropriately. So, under the Constitution, the preamble is, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. It's not the United States, it's the United States of America. And what is posterity forever. Everybody under you has that, whatever you had for yourself, which is the blessings of liberty. That means you are free. And my mom died a year ago, last May. And recently, my daughter and I were going through her books. And on her bookshelf was this book, which she had when she was in school. And it's called The American Creed. And the American Creed says, I believe in the United States of America as government of the people, by the people, for the people, whose just powers are derived from the consent of the governed. So who are being governed? The people. It is a democracy in a republic. Now, democracy is not a word that's in the Constitution, okay? But democracy is the legislature and how it operates. A sovereign nation of many sovereign states, a perfect union, one and inseparable, established upon those principles of freedom, equality, justice, and humanity, for which American patriots sacrificed their lives and fortunes. I therefore believe it is my duty to my country to love it, to support its Constitution, to obey its laws, to respect its flag, and to defend it against all enemies, both domestic and foreign, which is in the oath of all employees of your government. This is an authorized version. It was published in 1921. Congress of the United States began and held at the city of New York on Wednesday, the 4th of March, 1789. The conventions of a number of the states, having at the time of their adopting the Constitution, expressed a desire in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clause should be added. And as extending the ground of public confidence in the government will best ensure the beneficial ends of its institution. All right, Congress of the United States, resolved by the Senate and House of Representatives of the United States of America in Congress assembled, 2/3 of both houses concurring that the following articles be proposed to the legislature of the several states as amendments to the Constitution of the United States. All or any of which articles, when ratified by 3/4 of the said legislature, to be valid to all intents and purposes as part of the said Constitution. Articles in addition to and amendments of the Constitution of the United States of America proposed by Congress and ratified by the legislatures of the several states pursuant to the 5th article of the original Constitution. Note, the following text is a transcript of the first 10 amendments to the Constitution. Were ratified December 15th, 1791, and formed what is known as the Bill of Rights.
So yeah, let's understand the historical context, right, Suzanne? So 1791, which is what, if 1776 was the beginning of our nation, that's several years later.
Well, the Constitution was created in 1789. So 1776 until 1789, we did not have a Constitution. All we had was what is called the Articles of Confederation. And the Articles of Confederation is still valid today. And in the United States codes, you will find in Volume 1 in the preface all of the organic laws of the United States applying to every individual within those independent states. And then from 1789 until 1791 is when Congress put together these amendments, which are called your Bill of Rights. And they're only the first 10 amendments. And what was actually sent to the states, there were 11 of them, but 10 were the only ones that managed to be put in our Constitution.
Yes, and when, they have one thing in common. From what I understand, they're all there to limit government. When people use the word rights nowadays, they mean all kinds of things. I have a right to be free from illness. I have a right to be safe. I have rights to everything. I'm sure you can come up with several examples where you've heard people saying, I have the right to this and I have the right to that. And the government should give me this and the government should give me that. And the government should make sure that I get all the things that I have a right to. But that's not the real understanding of rights as far as I've come to learn, Sue Ann.
No, it is not. The rights are those that you were born with. And when you're born with these rights, then no one can take them away unless you agree and become a slave to the statutes. And the statutes are just rules by which those who are engaged in an activity or is government employee or is a corporate officer, not the employees. And all of the Bill of Rights are prohibitions to the government. They cannot do any of those things. But if you take a look at the statutes, how many of them interfere with your right to religion? How many of them interfere with any of your other rights, which we will be going through shortly?
And the other thing to understand, if you will confirm, Sue Ann, is that these Bill of Rights don't just apply to the federal government of the United States, but they apply to every state government, every county government, every city government.
Yes.
And they apply to corporations, which are created in statutory law.
Yes, they are. They're created by the state or by the federal government. There are some that are federal government, but usually what they do is they go into the state and they decide they're going to be a corporation in that state, and then the state gives them the ability to do that if they pay. So when you do that, then you can be a corporation, and then the legislature can rule and regulate your activity as long as you are an officer of that corporation. In doing the amendments, I'm not going to read all of them, but the first one is so important, okay? Because this is one that even if you have become under a contract with the government, this first one is the one they cannot get past to apply it to you, even if you're in a position in which you are either with the government, with a corporation, or with a regulated activity. There are certain things they cannot get past, and the Amendment 1 is one of them. So Congress shall make no law respecting the establishment of religion or the prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of people peaceably to assemble and to petition the government for a redress of grievances. That amendment in itself is a complete prohibition towards any government, state or federal, for them to make any law respecting those areas. But if you take a look at a lot of the statutes, both federal and state, they do all kinds of laws in respect to religion. So let's talk about religion, because I think that's real important. If you are a church and you become a 501c3, you become a corporate church. Guess what? If you become a corporate church, then the government can rule and regulate this. And the first time this came to light was in the 40s, 1940 something. And what happened was the Indiana Baptist Church was a very successful church. And IRS had told them they could not talk about anything to do with the military. And so they always said, all right, well, we only are going to talk about God anyway, so we don't need to worry about that. So because we've become a 501c3. So when they started selling books and things like that, IRS wanted some of their money because they were such a successful church. So they took them to court. And this case went all the way to the U.S. Supreme Court. And the U.S. Supreme Court told them, because you are a 501c3 church, then you are subject to the rules and regulations of IRS, as well as several of the business codes that are in our statutes. And these people, no matter how successful they were, realized they had given away their rights, whether or not they knew it. So let's talk about giving away your rights, because whenever you get a license, a permit, become a corporate entity, all of those have to have been done by what is called full disclosure. If you have not been informed of what you are actually giving up, then it is not a valid application or contract. And so you have to do it knowingly and willingly give up your unalienable or constitutionally protected and secured rights. So you can see that can be quite an interesting process, but you have to know it. And if you do not know it, what are the chances of you getting out from under something that has locked you into statute rules? And of course, the amendments are for you to read each and every one of them, but most of them I will not go through.
The ones I think would serve people best to focus on are the ones that we're going to use in our petition in the ex parte hearing. To my mind, these vaccine mandates, these threats of losing your job or not being able to go to school if you don't take the vaccine, violate every single one of these amendments, I'm sure. But in our petition, we're suggesting that people focus on a few of them.
Number one, which is the most important one, okay? Because it doesn't matter if you're in any of those regulated activities. And then Amendment 4, the right of the people to be secured in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. That one is one of them that we use with the COVID-19 and the vaccines, because they want you to sign paperwork telling them about your medical. And of course, we have that thing called HIPAA. Now, I don't know if anybody knows about HIPAA, but that is one of the worst ways that they can get your information and pass it on to other people in the government. And I think it's really the worst thing that could ever happen. But we are using this to say that if they asked you to do these things and they tell you that if you don't, they're going to reprimand you, or they're going to fire you, or whatever their threat is, that this is an injury to you and they cannot do it, and you are not giving that right away.
Very good. HIPAA is an interesting contrast. We're here today to contrast statutory rules with the constitutional protected rights, natural rights we have. Many of you have been required to submit your vaccination status at some point. It's only your right. If you want to give it up, you can, but it's your right not to. This is what we might call the right to privacy. It's often called the right to privacy. Mm-hmm. And it's ironic that the HIPAA law is in fact the title of HIPAA. The P in the HIPAA is privacy. It's Health Information Privacy Act. So this is a very interesting case of how you, just by being born, have a right to privacy. And the people who wrote the Bill of Rights here in Amendment 4 specifically called out that right to privacy. But then years later in our country, legislators determined that they were going to determine when and where your privacy as regards to health matters is allowed or not allowed. And so unfortunately, if you go to court with a lawyer today, the lawyer is going to study HIPAA because they live in the world of statutory rules, and they're going to be combing through that very, very large set of statutes and codes called HIPAA, and they're going to be looking for some clause in there that's going to get you off the hook. And unfortunately, they've done that over the last year, and many lawyers, including the Department of Justice lawyers, have concluded through their analysis that there's nothing in the HIPAA law to prevent employers or schools from requiring vaccinations as a condition of employment or attendance at school. So for those people, because they live in only the statutory realm, once they do their analysis of HIPAA, they determine that there's nothing there, so you don't have a leg to stand on. Right. And that's why lawyers aren't coming to help you. But they neglect this amendment. In addition to the privacy part of it, where you're secure in your person's houses, papers, and effects, that includes your vaccination status, it also says perhaps you've done something criminal, you've harmed another person. There is a mechanism for people to get information from you when you are being accused of a crime, a real crime. So that's where warrants come in. So people have a lot of different ideas about warrants. But indeed, if you understand what's going on here, these quote unquote community health mandates are designed to protect the general health of the community, so as they say. But what's implied in that is that you are a threat to the community, that you might have a virus in your body and you might be spreading it to others. You've heard this before. The problem here today, though, is if you are indeed harming another person by spreading a deadly virus, they need to be able to prove that. And that's the part that they're not doing. They're not giving us due process of law. They're not accusing you outright, individually, as someone who's a threat to the community because you could harm people. You are harming people because they can't prove it. How can they prove that if someone gets sick from COVID, that it's because of you? Because not only because of your proximity to them, but because of your willful intention to cause harm to them by actively exposing them to this deadly virus. In order to get a warrant to see your vaccination status, to have the authority to to peer into your private information, they would have to establish a warrant to get that information. And a warrant can only be given when there is a probable cause.
And the probable cause must be verified. In other words, it can't be, I think this. It has to be, I know this.
So it's not only a breach to your privacy, it's also a breach to probable cause, a breach to your right to know who your accuser is, to have them have to go through the trouble of establishing some sort of probable cause before accusing it. But as it is today, all of us are already deemed guilty of a crime just by being alive. And this is a huge breach to our natural God-given rights.
Correct. Very good. Okay. Amendment 5, I'm going to go to where it starts with, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. So, how many people have closed their businesses? How many people are on the verge of closing their businesses? Well, according to this amendment, nor shall private property, that means your business, be taken for public use without just compensation. But it's also, if you end up closing your business, you're entitled to just compensation to have closed your business. So I think the federal and the state government owe a lot of people a lot of money for their business.
If these county health departments had to give just compensation to every business that closed, they wouldn't have been able to do it because they wouldn't be able to afford it. It would bankrupt them.
Mhm.
So that's why they sidestepped this one, obviously.
Absolutely. And then Amendment 6, that has to do with criminal prosecutions. And then Amendment 7 is suits at common law. Okay. Suits at common law where the value in controversy shall exceed $20. Well, that's $20 in 1791 dollars. The right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. Now, I don't know about you, but I've been to court a number of times, and they will tell you California does not have common law. Well, gee, how do you get rid of common law? They can't, but they like to tell you they have. And so you're going, oh, well, how do I get this under common law? And it has more to do with how you put it together. And in the First Amendment, we talk about the petition for redress of grievances. And that is what we're doing with our conditional acceptance or our direct and constructive notice, and doing the entire process. And that puts you in a position to be able to do common law. And most people would never know that. But I will tell you, the judge knows it. And are you familiar with what happened in San Francisco? We have two judges. One is the presiding judge. The other judge is actually an elected judge. The presiding judge is an appointed judge. And when we refile, it will go to the elected judge only, not the appointed judge.
Yes, very good. So we might as well tell people right away that we're working to get this petition together to go to court, and we're going to make a template of it and make it available to everybody very soon. In fact, Sue-Ann, I know you and I haven't talked about it, but there are many people who've been through all the way through all of the paperwork, through the
Good.
notice of violations, and they're ready to work with this. I'm prepared, if you are, Sue-Ann, to take up any number of people here and work with them in a workshop fashion online here
I agree.
to help them write their documents and get them moving, not wait for the city and county of San Francisco employees. They can start going to court now.
Absolutely. We're looking forward because number one, once you have done either the conditional acceptance or the direct and constructive notice process, completed it, it is a petition to your court. It is not a complaint. It is a petition because you are petitioning for redress of grievances of which you have already completed the process by which you get your remedy. And this is something that people need to know. So that petition for redress of grievances is what you do when you want to go to court and it becomes an ex parte hearing, but it's not actually a hearing. Technically, an ex parte under common law is you and the judge in his chambers. He then looks at your paperwork, says, oh, yes, looks like you did a proper job. You are therefore entitled to your remedy, but it's only through the petition you get your remedy. Okay, so Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. It's the people that have the rights. You give out a few of your rights to the government, but they are secondary. They are not first. Amendment 10. The powers not delegated to the United States by the Constitution. So how did we create the federal government? Through the Constitution. That is where we have given them certain rights and we have all the others. Nor prohibited by it to the states, are reserved to the states respectively, or to the people. So who are the ones that really have the power? Isn't the state, it isn't the federal government, it's the people. But the people need to know that they have that. If they don't know it, then they are just a slave. This is California Constitution 1849. Preamble in the California Constitution is, we the people of California, grateful to Almighty God for our freedoms in order to secure its blessings and do establish this Constitution. So California's decided that it definitely is going to be God. In the federal Constitution, it's the creator. The people of California are the ones that have the power.
So a lot of people are not in California here and they're asking, what is this the same for me? And yes, absolutely. This is your opportunity to go read your state constitution. Everybody here, please put on your to-do list today to go read your state's constitution and understand there's going to be similar language, but it's every state constitution a little bit different. At least read the preamble today.
And I would do the preamble and the Declaration of Rights, which is within your Constitution. Those are the most important parts that you need to read. Okay, so there's Article 1, Declaration of Rights, Section 1 all the way through 21. Now, I didn't list them. If you want to read them, that's up to you. But I did do Section 21. This enumeration of rights shall not be construed to impair or deny others retained by the people. Have to understand, the people are the ones with the rights. All others are given privileges. So your federal government has been given privileges through giving up your rights that by yourself you really couldn't put forth, such as a military or coining money or certain things that are for the entire people, not for just one person. Okay. So those are things that I thought were so important. People have to understand who they are. All right. So first, we have your creator. Some people call him God. Some people call him something else, but it's who you believe created you. Then there's you in this scheme of things. Then there's the government. Your ancestor created this government through the Constitution. So you have common law or statutory rules. Common law has 4 laws. One is called a tort. Tort is damage to person or property. That is a tort. That's everything from stepping on your toe or actually saying that you've done something bad and you haven't, okay, all the way to murder. So that's a tort. Trespass, and I think most people understand trespass. That means you are entering onto land that is not yours, and there's someone there who can say that you have trespassed, and they then can take you to court for trespassing. They have other trespasses that become a little more technical, so I won't go to those trespasses. But when you're on public lands, which is not land that you own, but the public owns, they cannot throw you off. That is your land that they are managing. They do not have the authority to throw you off of that land. The next one's called breach of peace. What is breach of peace? Well, when I was teaching this back in the 90s, it used to say that if you go to a theater and we're all watching a movie and you're sitting in the back of the theater, and in the middle of the movie, you stand up and yell fire, and there is no fire, that is called a breach of peace. Okay. So if you take a look at Fauci, let's see what he did. We're going to tell you that we have this pandemic and we're having everybody afraid of this pandemic when there is no pandemic. Then the last common law is a violation of a contract. If you do a contract with somebody, say you're going to do a contract with someone who's going to paint your house, and he comes in and he collects a down payment. You've signed this contract and he does not actually paint your house, or he paints some of your house but not all of the house, then you have a case against him for failing to do his duty so that he can get paid. Okay, that is a violation of contract. Those are your 4 laws. Everything else you have a right to. So now we go over to statutory rules. Let's see, there's 61 million plus rules. Too many to evaluate. To whom do these apply? They apply to government, either elected or employed, corporate officers, not the employees, and one in a regulated activity. So my favorite has always been traffic. And so if you are in traffic, that means you are transporting persons or property for hire. The last two words are absolutely critical in this. So if you are in a regulated activity, but the statutory rules cannot apply for anything in the First Amendment. That stops any of those areas. If they violate that First Amendment, then they cannot apply that to you, even if you're a government employee, a corporate officer, or one in a regulated activity. Okay, I'm going to do a couple of court cases because I thought they were rather interesting so that people have an understanding what our courts do. And if you look at the bottom, it says Clearfield Trust Company versus United States. And then it's in the 318th volume of the United States reports. The Clearfield doctrine is governments descended to the level of a mere private corporation and take on the characteristics of a mere private citizen, where private corporate commercial paper, Federal Reserve notes, and securities checks is concerned. For purposes of suit, such corporations and individuals are regarded as entities entirely separate from government. So you take a look at that. Government descending to the level of mere private corporation. Now, I've done several court cases, and they finally got to the place where they are now telling you that they are a corporation. It's called a municipal corporation, but they're still a corporation. And they cannot go against the people. They can only go after other entities that are within the realm of having business to do with them, but they cannot go after the private citizen, but they do it all the time. And my favorite case is a case in Mendota in which a man was re-roofing his home, and the building inspector came along and said, "You have to have a building permit." And so he went to one of my students who called me and asked what to do. So I told him, I said, tell him to write a letter to the building inspector and ask him what his authority is and to whom it applies. So they wrote the letter. I never saw it, so I have no idea what it was. But they then got a letter from the city attorney. And in the city attorney's letter, he states that this is the code section. And it started out by saying, for those under this code, these rules apply. Okay, well, all right. For those under this code, that means there are some people that are and some people that aren't. So they sent me the letter and I responded to it, and I delivered it to their office on the same day. In a couple of days, they get a letter from this city attorney, and it's a one-page thing that says the city of Mendota will follow through on what was in their first letter. If you have any questions, please contact an attorney to get the questions answered. Well, then I did my famous letter. And when I was done, the city of Mendota had their weekly meeting. They fired the business manager, they fired the city attorney, and they wanted to fire the building inspector, but he went on 4-month leave of absence. When he returned, No one wanted his job. Now, okay, what does that mean? Why didn't somebody else want his job? It was a good paying job. Nobody wanted it. Why? You have to think about those sort of things. But that was one of my favorite ones of all the things I've ever done. That was definitely my favorite.
So this is a big truth bomb for people today, people facing a vaccine mandate or heading into the court, petitioning the court for remedy in the form of an order to cease and desist and pay damages.
This tells you if you're going as if you are in a regulated activity, then you're dealing with the private corporation, municipal corporation. The federal government is also a corporation. It became a corporate entity in 1871. And the only way you can do it is under common law. And when you do an ex parte, and what it is ex parte says, I have one person that's going into the court to ask for remedy because they have done a process by which they did not get response. Because if you send letters to these people and they do not respond, then they have agreed with your paperwork. No response means I agree with your paperwork, period. And that's how you win your case.
The city government where you live, your county government, surely nowadays, every government, the state you live in, and the federal government, the United States is a corporation. Your state, the state of California is a corporation. There's the California Republic, which is our state. And then there's the state of California, which is that municipal corporation called the state of California, the state of Texas, the state of Maryland, the state of Arizona. These are all municipal corporations. So when you volunteer to be subject to any of the many, many, many rules and regulations and codes and statutes, you are in effect contracting with this corporation. This is an enormous truth bomb here. This is a big red pill to swallow. The implications of what we're saying are extensive. And so just really want to let you first deal with the fact of the matter, that you have two things going on when you're a free people and you're the sovereigns of the land in which you live, your state. It's two different things we're talking about. Common law, the original law, God's law, the true law. You and your people in your state are the sovereigns of your state. And then over the years, somebody came along and created something called a municipal corporation, or the state of California, for example, and built up an entire apparatus that is separate from you, the people, and the land, except for the fact that we have all of us, knowingly or unknowingly, as Sue-Ann points out, contracted with or come into agreement with by applying for a driver's license, by applying for Social Security, by registering for the draft, by getting a business license, establishing a corporation, even a business corporation or a nonprofit corporation, or the corporations that are specially for religious organizations like churches. All of these things are under the statutes of this apparatus, in our case known as the state of California, which is none other than a municipal corporation. So again, there's a lot of implications about this fact, but I just want to make sure that fact really gets firmly established. And then you're going to, over time, start to see how that really matters in your life on a day-to-day basis, and what it means to, quote unquote, follow the rules and not get in trouble, and all the fines and fees and citations that these various organizations and state agencies hand out like candy in order to profit themselves. And so it's really good news to learn, isn't it, today, that you are not subject to those laws unless you have volunteered to. So it's a big awakening for a lot of people, right, Sue-Ann?
Yes, it is. And I will tell you, there are cities in every state that are not incorporated, but trying to find them can be a little bit of a challenge. All right, we have two different and distinct nations in this nation, okay? You have the United States of America, and you have United States. Isn't that interesting? And so we say United States, and you leave America off. Which one are you talking about? And this is something um, the codes talk about whenever you have that. The idea prevails that some, indeed it has expressed in argument at the bar, that we have in this country substantially two national governments. One to be maintained under the Constitution with all of its restrictions, and the other to be maintained by Congress outside and independent of that instrument by exercising such powers as other nations of the earth are accustomed to. I take leave to say that if the principle thus announced should ever receive the sanction of a majority of this court, a radical and mischievous change in our system will result. We will, in that event, pass from the era of constitutional liberty, guarded and protected by a written constitution, into an era of legislative absolutism. You can continue to read this at another time, but that is what you have to understand. And when you get into agreements and licenses and permits and things like that, you give away many of your inalienable rights. Common law is in every country in the world, but the people don't know it, and they can't utilize that what they do not know. So you have to learn how to know that you are in charge in that courtroom. I mean, I had one of my students recently had a court case, and he went to the court. And when he went, I told him, whatever the judge tells you, tell him you don't wish to do that. And he did that in his first hearing. And what happened was the judge told him to put a mask on. Now he's on Zoom, and the judge wants him to put a mask on. Okay. And he looked at the judge and he says, "I'm sorry, Your Honor, I'm not going to do that." And the judge, he was shocked, and he goes, "Well, okay, well, we'll have to reschedule your hearing when we're going to do this on such and such a day." And the guy just let that happen. Okay. Went home, was home for 2 weeks, went back to the court, and the judge, and of course he didn't wear the mask, and the judge says, "Oh," he said, "they have not responded to your paperwork, and we will dismiss your case." The guy was absolutely exuberant on the fact that he actually won this case, and it was a speeding ticket. After he'd done the first one, he calls me and he says, "Oh my God," he says, "I felt like a king." And sometimes that can be a bit of a challenge for people who are timid. And I realize that, which is why a lot of people get attorneys. That attorneys, their first duty is to the Bar Association. The second duty is to the court. A third duty is to the public, and you come last on the list. I had to have an attorney because when I got out of the hospital, I could barely walk, couldn't talk, couldn't read, and couldn't write. So they got an attorney for me. Well, I selected my attorney, and my son decided he didn't like that attorney, so he got another attorney, and that attorney took advantage of me big time. So I was never happy with that situation. So. Yeah, it's the Honorable Supreme Court Justice John Harlan, and he was a great judge. In 1901, in a case called Down versus Bidwell, and I didn't get the case site on that, but it's one that I used in several of my court cases back in the 90s. Okay, Supreme Court of the United States, 1795. So this is 4 years after we did the Bill of Rights. Inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality or substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate, artificial person, and the contract between them. The SCR means Supreme Court Reporter in Penn Hollow versus Doan's Administrators. And then that is the site, and that's a real old site because the DAL is the first 4 letters of the reporter's last name.
There it goes. So now, yeah, okay, thank you. It's showing up now.
One of the law books is called 16 American Jurisprudence, 2nd edition, section 70. And it quoted, no public policy of a state can be allowed to override the positive guarantees of the United States Constitution. And that includes the Bill of Rights. The next is a In Re Self versus Ray, and this is from Wisconsin, and their 2nd edition, 1983. The common law is the real law. The codes, rules, regulations, policies, and statutes are not the law. They are the law of government for internal regulation, not the law of man in his separate but equal station and natural state, a sovereign foreign with respect to government generally. Now, I don't know about you, but I think that's really important.
Well, particularly to government employees, because, even in our documents, it says except for government employees. And we've been saying that these rules and regulations do apply to the employees of the government. And yet here it says right here that you're still a man or a woman, and you have a separate and equal station and a natural state. And that's the part that people actually forget. They think that as they become an employee or even just a regular person being regulated by the vehicle code or all the tax code or the business code or all of the various statutes that we've been talking about as examples. But even before all of that, there's just you in your natural state. And that's what we're here to remind you of today.
Right. And that is what our paperwork works on, because you are in a natural state, no matter whether you are a government employee, a corporate officer, or you're in a regulated activity. Those are certain things that they can get you to do because you're employed. But if it's something that you take home, they can't do it. And I think the vaccine is something you take home. Robin versus Hardaway. This is a Virginia general, and it was done before we became the United States of America, 1772. The laws of nature are the laws of God, whose authority can be superseded by no power on earth. A legislature must not obstruct our obedience to him, from whose punishments They cannot protect us. All human constitution which contradict his laws, we are in conscious bound to disobey. Such have been the adjudications of our courts of justice. So at least in 1772, they had courts of justice. How many courts of justice have you heard about recently? They got rid of them. But that doesn't mean they got rid of common law. They cannot get rid of common law. They'd like to, but they can't. Cruden versus Neal. This is from North Carolina, 1796. Every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Forney versus First National Bank of Shreveport, 1941. A code or statute is not law. God, I wished I'd known that back in the 90s. Because then I'd really been dangerous. But I won, so I guess that's all that counts. Okay, which do you want? As a free inhabitant, that's in the Articles of Confederation, Article 4, you may follow the common law or statutory rules. It is your choice. When you give up your unalienable rights for statutory privileges, you become a slave to the state. Doing statutory rules can be done, but at what cost? This is the reason we do the Great American Law series. It explains it in a very basic way.
The Commoner Law Group created the Great American Law series toward the end of last year, and we began delivering it early in this year, 2021, before the mandates really. And our overall policy was to make sure that everyone took the fundamentals course before working with anybody on their particular situation. But then the mandates happen, and it's an enormous tsunami, and hundreds of thousands of people are being affected. So we said, instead, we're just going to start working with people, even though they've never heard of any of this stuff. We're going to put in front of them these documents that kind of speak for themselves and are a bit of a primer in and of themselves. And if they should be willing to try something unusual, perhaps, and then serve these documents on their oppressors, the people threatening them in order to try to get them to take the vaccine, those people then would learn along the way. And that's exactly what's happening today, is that we're all continuing to learn along the way. But our commitment really is to backfill and to make sure everyone knows exactly what's happening here. Because in as much as these vaccine mandates are an enormous breach of our rights, we still have to think of our posterity and the future. And what the Commoner Law Group is up to creating is a movement across this land to restore the original law and to remind people and return people back to their free selves as, you know, your God-given birthright, and then to act that way, and really will transform our entire nation. And so please consider taking the Great American Law series today. You can go to commonerlaw.com and sign up. There's a 30% discount for anybody who's facing a vaccine mandate. Really, we do want you to be active in learning and pursuing justice through these series of documents and ultimately an ex parte hearing. But when you have extra time now, if you have extra time, please do this online self-directed course, and you will once and for all have for yourself an absolute clarity about who you are, the role of government, what jurisdiction means, what crimes are, what the Constitution represents, what the Bill of Rights represents, everything you need to know, what's a right, what's a privilege, a must-do education for anybody who wants to be genuinely free. And then you'll be a resource for everyone in your life to go out and share. Once the torch of freedom is lit, it just spreads, and that's what we're counting on. So thanks for letting me advocate to you for that course. Wonderful, wonderful presentation. And it is absolutely a choice. I love the way you finished. What do you want? It's a choice.
It's your choice. Each and every one of you have a choice. And what you do is what is best for you, because that's what you want, is you want what's best for others, not for yourself. I already know what I'm doing. Uh, I I have gotten into law in the 90s, and I had many court cases. I was very successful. I had, several things that I did that were really good. And then I met Fritz, and life has been a whole lot better since then. And I've been working on the San Francisco case, and it is amazing the things that we learn, because there were certain things we didn't know when we found out that the government for the state had decided that ex parte was actually a two-party thing. Well, ex parte is not a two-party thing. It is only for one person, and that is to give them remedy after they've done letter writing, and then it works for them, and the judge looks at it, verifies that it's valid, and then he gives you remedy, and technically you don't really have to go to court. So we're finding it interesting that they've got this set as a hearing, and we're kind of hoping that it will change back to the way it used to be. But right now we've got a hearing. They plan on going on Wednesday, so we will know very shortly the bottom line for this one.
I'm talking to a lot of people, everything from people who are still considering the medical. I talked to a woman yesterday who said she applied for the medical exemption after hearing one of our presentations. And you know what she said to me? She said, I was looking at the common law thing. She's not from America. She's from a country that they don't have this tradition of freedom and common law. So it was completely foreign to her. And she gave it a listen. And she told me that she ended up going with applying for a medical exemption because it seemed like if the common law approach, I would have to fight. That's what she said. She said, with a common law approach, it seems like I would have to fight. And I said, well, I guess you could put it that way. It's a fight, especially in this time. And just, I don't know if there's anybody out there considering these exemptions or if they're going through it themselves. She also reported to me that after she put through her application, which was extensive in terms of trying to establish her religious sincerity, her religious conviction sufficiently for her overlords to determine whether she, was religious enough to deserve an exemption. She hasn't gotten a response after a couple of weeks, and she continues to get more questions. So there was the initial application, and then she gets more questions and more questions. The most recent set of questions was asking her about what other medications she takes. There was a big long list. It's everything from ibuprofen to Claritin and different, all these over-the-counter medications. And they asked her, to check which one she uses, and then to explain how this medical intervention is different to other medical medicines as far as her religion is concerned. So, they really, huh? Can you believe it?
No.
And people are willing to jump through these hoops. So because she's such a rule follower, working for the city and county of San Francisco, and she wants her pension, and she's conditioned herself to, go along to get along. She is jumping through all these hoops, and she'd rather, I guess, jump through hoops as a subject, as a subordinate to this municipal corporation than to fight for her rights. So that's a choice she's made. So most people think that we need rules and regulations, and then we need the government to order society. Otherwise, it's going to be chaos. And I actually believe that the powers that be create chaos to instill in us a sense of instability that then has us want to believe that we need some sort of superstructure to organize life so that to save us from all this chaos. But I don't believe that most of the chaos is real. For starters, it's exaggerated, it's instigated, and in that true commoners living a wholesome, healthy, productive life, we can arrange our affairs just fine. This call is going to be coming to an end. This was our initial lesson of many lessons that are coming very quickly to help people get into court. But the very fundamental question of what's the difference between walking into a court that's a common law proceedings versus a statutory proceedings. And that's what we began today to teach those elements. And we're going to continue to build in those fundamentals as we give you specifics about what documents you need, templates, and we'll even do workshops, I believe, would be a really great way, Sue-Ann, to help people just create their own documents. We'll take out the templates, and then we'll start working through them. We'll take different people from different places around the country with different situations and help them customize their documents and get them in the process. They'll become empowered because they're reading the documents and they're seeing through the wording in the document what their authority is, and they'll be encouraged and develop more confidence, and then ultimately take them through the paperwork that they need to file with the clerk, and what all that means in terms of who the clerk is for you, and what kind of judge you're going to get, how to instruct your judge, and then how to prepare all the way up to the day of the case itself, which should happen very quickly because these are emergencies, and how to behave in court as well.